Chair.
I call the Honourable Minister Chester Burrows.
Mr Chair, I take a call just to respond to some of the points raised by the Honourable Leanne Dalzell, and obviously she has, with her experience, recognised that there have been some issues that have been spoken about amongst the family legal fraternity that have need to be addressed, and it is important to point out that in the consideration of this bill and further on in the implementation of it, there will be some regulations which will, for instance, prescribe the portion of lawyer-child costs which parties are required to pay as 2/3, but by default this cost will be split in equal shares between the parties. It's also important to note that, however, the court may substitute a different share for a party if satisfied that in the circumstances of the case it would be inappropriate to require each party to pay an equal share. And the substituted share may not exceed the prescribed portion, so no party may be required to pay more than 2/3 of the cost of the lawyer. Now, there are obviously needing to be built into this some safeguards, and the safeguards are all around the paramount principle of the Care of the Children Act 2004, under which the most orders are made, is that the welfare and best interests of the child are paramount. Therefore, any decisions about costs orders must be taken with that principle in mind. So the court may decline to make an order of costs at all if satisfied that it would cause serious hardship to either party or to a dependent child of the party, and the court may adjust the default equal share of costs if it's considered inappropriate. It's also to be noted, for instance, that even as part of the family court review that the previous speaker mentioned, that there are a number of alterations that have been made there in respect of, for instance, allowing legal aid to be granted for counsel to be provided in the preparation of parents who will be representing themselves, because it recognised that there was an equity of arms if for instance, one party with a substantial income was able to go and get coaching, if you like, from a legal counsel, they would be better prepared. So it was important in the interest of justice to allow that to happen under that particular bill, and I think it is important to know that legal aid is actually moving to recognise that there have been these issues. And I guess just one final point to make in response to the court's ability to alter or to waive the imposition of the cost of counsel for the child. In the implementation or the institution of fees and filing fees in the family court, there was a lot of noise about the fact that these had never been in place before. The point was made that waivers would be granted or able to be granted in circumstances. In actual fact, 70% of the matters appearing before the family court now receive a waiver. So any argument that says, well, the court will be unlikely to do that, or the Ministry of Justice would be unlikely to give waivers, is actually not an issue. It hasn't proven to be an issue under that particular regime, and no one would expect it to be in the future.
I call the Honourable Member Andrew Little.
Thank you.